and thank you for joining us for today's webinar on municipal tax enforcement with the Ministry of Government Relations. My name is Adam Brome, and I am a Junior Communications and Events Coordinator with SARM. We'll start off today's webinar, as always, with a few quick notes regarding the platform functions and session format. We will then transition into the main presentation, which will be followed by a Q&A session. This webinar will be recorded, and a copy of the recording will be available to view on our webinar's webpage following today's session. Please let us know if you are experiencing any technical difficulties during today's webinar through the chat. The chat box is located on either the top or bottom portion of your screen. Click on the comment bubble icon to view or participate in the chat. The chat will be visible to all webinar participants and presenters. Sorry, I'm just letting more people in. Bear with me. The chat is also where you can submit any questions that you may have for the question and answer session. All questions will be answered following the presentation, and if we do run out of time before your question has been asked, you can either contact the ministry directly or we will share some of those answers with you guys in a separate email following the session. We will also be distributing today's presentation and the recording to all attendees via email following the webinar. And again, if you're having any technical difficulties during today's event, please notify us through the chat and we will do our best to troubleshoot with you. So without further ado, I will now hand it over to Brian Ricochi, SARM's Manager of Advocacy, who will be moderating today's webinar.
Thanks, Adam. Yeah, like Adam said, today we have a webinar on municipal tax enforcement. We felt like this was a good topic to have for our membership, as it's been on the advocacy side of things. It's been something that we've been working with very closely with a lot of our membership, as well in conjunction with the province, especially with the Ministry of Government Relations, on trying to hash out some issues and try to find some tools and solutions. And one of those tools, I think, is this presentation today that will hopefully allow for people to get more comfortable with some of the tools we have and some of the ability that they have possibly to increase their municipal tax enforcement. So with that said, today we have Tobi Duck. Tobi is a municipal advisor for the advisory services and municipal relations at the Ministry of Government Relations. A little bit about Tobi. Tobi started her municipal administration career in 2008 as the administrator for the town of Grand Coulee. And after nearly 11 years there, in March of 2019, she joined the advisory services team with the Ministry of Government Relations. So with that introduction, Tobi, I will kick it off to you to start off with our presentation.
Thanks, Brian, and thanks, Adam. And good morning, everyone. Thanks, SARM, for inviting us here to discuss municipal tax enforcement. As Brian said, my name is Tobi Duck, and I am a municipal advisor with the Ministry of Government Relations. Okay, and you'll have to excuse me. I am working two screens here, so just bear with me. So, as you are probably aware, Council has a lot of natural person powers, subject to any limitations contained within the Municipalities Act or any other legislation. Municipalities do not need specific authorization for their activities, provided the activities fall within municipal purposes. However, when it comes to taxes, whether it's levying, collecting, or enforcing tax collection, this is not a natural person power. There must be clear authority within legislation to do anything when it comes to taxes. And the two legislations that provide this authority that I'm going to speak to are the Municipalities Act and the Tax Enforcement Act. Why is it important to enforce the collection of taxes? Some people might think these are apparent, but not everyone does. Tax revenue is the primary source of money for every municipality to operate. The sooner you start the enforcement of tax collection, the likelihood of collecting is better than waiting until the property is years into arrears. The Tax Enforcement Act requires that land that is in arrears to be added to the tax enforcement list. And the last reason for enforcing the collection of taxes would be fairness. If some people choose not to pay their taxes and the municipality does not enforce it, is it fair for all the others to be paying their taxes And what kind of precedents are you setting there? Or what message are you sending if they do not enforce the collection of taxes? That it's okay? It is an expectation that everyone pays their taxes. Let's be honest, tax enforcement is an unpleasant process, especially when you know everyone. In my former life, when I was an administrator, I did have to do tax enforcement on my friends. And yes, we are still friends today. So what you need to remember is when you were elected as a council member, you were elected to make decisions on what you believe is in the best interest of the municipality, not what is in the best interest of individual people. Before we get into the enforcement of taxes owing, I would like to take a little time to explain the process of levying taxes. The first step deals with property assessment, which council has very little to do with. As this presentation is geared towards council, not administration, I'm going to keep this part high level. Every year, the assessor, who is the administrator, is required by May 1st to prepare assessments for each property in the municipality. Once the assessment roll is prepared, the administrator must send assessment notices, make the assessment roll available for public inspection, advertise in the Gazette and in one newspaper, and provide the ability to appeal assessments. After this is finished and any appeals are finalized, legislation requires you to have your assessment confirmed by SAMA. If the assessment roll has not been confirmed, municipalities cannot legally enforce the collection of taxes based on those assessments. So it is essential that your roll is confirmed. Taxes are considered due and enforceable when the assessment roll has been confirmed and tax notices have been sent. Taxes do not go into arrears until January 1st of the following year. For example, taxes that were levied last year in 2022 are considered due, but do not go into arrears until January 1st of 2023. Once taxes are in arrears, municipalities must begin the enforcement process under the Tax Enforcement Act. During the first part of this presentation, we are going to discuss the tax enforcement process, and the latter portion, the non-title collection methods. My goal is to explain some of the options and rationale behind these processes. If you and the rest of council believe that the non-title collection method is the path that works best for your municipality, I strongly encourage you to speak with your municipal lawyer for assistance. There is a lot of legal processes involved in it, which I am not familiar with. Okay, so the Tax Enforcement Act defines land as land or any interest in land and includes buildings, parts of buildings, structures, and fixtures in, over, under, or affixed to land, but does not include machinery permanently affixed to buildings or embedded in foundations and those foundations. When taxes on any land are due and in arrears, the land must be dealt with under this act. What this means is the owner of land may not be the owner of the improvement. However, if the improvement is on their land and the improvement is in tax arrears, that land can be placed on the tax enforcement list. Tax enforcement is essentially broken down into two phases. Phase one involves the municipality providing notice that it intends to register an interest against land and then actually doing that. These are legislated duties imposed on the administrator, which means the administrator must comply. The administrator must prepare a list of lands in arrears and present it to the head of council. what a lot of municipalities do is they pass a resolution acknowledging this list. After that, the administrator will be required to advertise that list in the newspaper. And 60 days after the advertising in the newspaper, if the tax arrears have not been paid in full, the admin will register a tax lien on all the properties. And from there, you wait 6 months. Council has a very limited role here, but they do have a little bit of influence, such as establishing when the municipality will begin the process. So as early as January 1st, but no later than November 15th, the list of lands in arrears is required to be presented to the head of council for acknowledgement. Council might want this list to be prepared and presented the same month every year, so they could pass a policy requiring when the list is presented. My council wanted my list prepared and presented at the January meeting, whereas my colleagues presented it later in the spring or early summer. There really is no right or wrong here, but we strongly encourage not waiting until the 11th hour to start. We receive a lot of phone calls come November in situations where they have not presented their list and say the November meeting has been canceled. And what do you do then? Unfortunately, the Tax Enforcement Act does not say what to do in those situations. So then you have to do your best. Or if you run into any other issues or glitches. So start it sooner than later. Council also has the discretionary authority of exempting those properties that owe less than 50% of the previous year's levy. And 50% is the magic number there. They do not have the authority or the ability to say 20% or 60%. It's 50%. So council can pass that resolution every year to exclude those properties, or they can also have a standing resolution on it. And the other place where council has a little bit of discretion there or authority is what newspaper the municipality will be advertising in, as the list is required to be advertised in a newspaper that is circulated in the municipality. If there are no papers that are circulated, council can select a newspaper that is published in the province. I am going to detour a little bit from the Tax Enforcement Act and touch base on the Farm Debt Mediation Act. So prior to starting the second phase, which is the 6-month notice, there's an additional step which may need to be taken. And it falls within the Farm Debt Mediation Act. Farmers throughout Canada are conditionally entitled under Section 5 of the Farm Debt Mediation Act to have a review of their financial affairs, mediation, and obtain a stay of proceedings. This protection applies to all types of property in any type of municipality. If the owner is a farmer, and not just in Saskatchewan, but in any of the other provinces as well, the administrator will need to send this notification to the owner and to the Farm Debt Mediation Services. The notice must be sent at least 15 days before you serve the 6-month notice on the owner. And I've actually heard of one municipality who was about to apply to receive title, and it was actually stopped. There was a stay in it because they did not serve this notice on the to the property owner and to the Farm Debt Mediation Services. So it was actually overturned. So as a rule, best practice, serve it on everyone. I worked in an urban, as previously mentioned, and this was just something I always did, regardless if I knew they owned land, if I was pretty sure that they didn't, I always served this notice. Better to be safe than sorry. All right, back to the Tax Enforcement Act now. So 6 months after the tax lien has been registered, phase 2 begins. This is where the municipality takes those steps which can result in the owner losing the property for non-payment of taxes. To continue with the tax enforcement, council is required to pass a resolution authorizing the administrator to start proceeding for title. Council does have the discretionary authority here to delay the proceedings until such a time as council deems appropriate. Again, as a best practice, and this is something my mentor mentored me on, and when I talk to administrators and council, I encourage them to keep proceeding through this. Even if the municipality really doesn't want to take the property, proceed to the very end. Anyways, so if council authorizes the administrator to proceed, the administrator will then serve the Form C, which is the 6-month notice, to the owner and other registered interest holders. The administrator will want to pay extra attention as to who the other interest holders are. If Canada Revenue Agency is one of those interest holders, there may be a few issues. The reason being is the interest survives the title transfer, which means if the municipality takes that title, Canada Revenue Agency, their interest is not removed. It stays on the title. The good news is that the municipality can sometimes negotiate with CRA in order to make it worthwhile to proceed with title acquisition. The bad news is it can take a bit of time, or CRA will not negotiate. If that's the case, the municipality will need to consider if it's in their best interest to proceed for title. 6 months from Form C being served, the administrator will submit Form 5 to the Provincial Mediation Board, requesting the authorization to proceed for title. The Provincial Mediation Board, and if you hear me using PMB, that's who I'm referring to, will attempt to reach the owner to work on a payment plan. From my understanding, the Provincial Mediation Board tries to establish a payment plan that would see the arrears fully paid in 3 years' time. If the Provincial Mediation Board is successful in establishing a payment plan, they will not issue consent to take title. If the owner defaults on the plan, it is up to the administrator to notify the Provincial Mediation Board. Let them know ASAP that there was a default. If the Provincial Mediation Board does issue consent, the administrator will register the consent on title and then will proceed to send the final notice, which is Form G, to the owner and all other registered interest holders. 30 days from there, after sending the final notice, if the arrears and costs are not fully paid, council again has the discretionary authority to proceed or to delay the next and final step. If council passes a resolution to proceed, the administrator will then request ISD to transfer title to the municipality. And as I said previously, when we were talking about the 6-month notice, this is where I'd encourage all municipalities to proceed to, even if there's a payment plan worked out, or through the Provincial Mediation Board, or even with them individually, the property owner. Proceed to this part. Then if there are defaults, if something else should happen, you don't have to wait another year or 6 months to start the process all over again. And like I said, this part is optional. Again, council can suspend the proceedings. Some things to consider prior to taking title. At any point along the tax enforcement process, council will want to be cognizant of the state of the property. If there is any cleanup or demolition required, you will want to enforce this through your bylaws prior to taking title. If it is enforced prior to taking title, the municipality has the ability to add certain costs to the taxes, which then you might have a chance to recoup later with the sale, with selling the land. And those would be if the building is required to be torn down, or if there's a nuisance and you're issuing order to remedy. Those costs can be added to the taxes if they're not paid. Whereas once the municipality has taken title, if there's any work to be done, that would be the responsibility of the owner, which would be you, the municipality. You do not have the ability to add those costs to the taxes once you become the owner. We get that quite a bit. Those questions quite often is, we've taken the title and now we want to do all this cleanup. Can we add those costs? And unfortunately, it's no, you cannot, because you are the owner. All right, so some potential post-acquisition. After title has been transferred into the municipality's name, it is now referred to as tax title property. There may be a few complications that you might run into if the property is occupied or if there's unclaimed belongings left behind. What do you do? If the property is occupied, the municipality will now become the landlord, and the occupant, which may be the previous owner or they may just be renters, becomes the municipality's tenant. If you want to evict the tenant, you will need to contact the Office of the Residential Tenancies or talk to your lawyer to find out the proper steps to have someone evicted. However, as long as there is a tenant, the municipality has the ability to collect rent and use those proceeds to offset the taxes that we're owing. And I say we're owing because once the municipality takes title, those taxes are then transferred to a liability account. They're not going to be showing on the property. But if you're collecting rent, you would use what you collect to offset those liabilities. If there's any personal belongings left behind, the municipality, we point the municipalities to Section 406 in the Municipalities Act. And what it says there essentially is that the municipality must keep in its possessions for 90 days all lost or unclaimed personal property. If the property is perishable, it can be disposed of. Though it's not required, we do recommend that the municipality send a registered letter to the former owner, making them aware that they have 90 days to make arrangements with the RM to come and collect those possessions. They do not have the right just to come in and walk into their house or their land to get. We do encourage the municipality to communicate and try to find times that work best for both. If after 90 days they aren't claimed, they become the possession of the municipality, and the municipality can then dispose of them or dispose of them as they see fit. If the possessions are sold, the municipality can use the money to pay for the charges, if there were any, that were incurred to store the possessions, to haul them out, or even to sell them. So if you use auctioneer to sell the possessions, you can use the proceeds to pay for that. If there's any money left, the former owner does have claim to that for 1 year from the date of sale. If there's no claim to them after the 1 year, the proceeds then form part of the general funds of the municipality. Okay. So you've done all the steps. You are now the property owners. The property now is tax title property. It must be offered for sale by tender or by auction within 1 year. And there could be various stages to this, or various outcomes, sorry. One of the outcomes is the property may be sold for less than the outstanding costs and taxes. Council does have the discretionary authority here to accept or reject bids that are not sufficient to cover the amount of all outstanding taxes, penalties, and costs. If council rejects an offer that is less than what is owing, the municipality can then sell the land by private sale at the best price available. The property may be sold for more than what's outstanding for the costs and taxes. If an offer is received for what is outstanding, so arrears, penalties, and costs, that would be tax enforcement costs, or for more than what is outstanding, council must accept the offer, even if they feel that the property itself has a higher value. You have to remember the point of tax enforcement is to recover what is owed to the municipality, not to make a profit. Prior to the sale of the tax title property, the municipality may choose to rent or lease the lands as council sees fit. and distribute the proceeds as outlined in Section 33 of this Act, which I'll be discussing in the next slide. Or the property may not be sold. The municipality can retain the property for a municipal purpose. If this is the case, the municipality will then have to compensate the school division and any other taxing authorities for its share of the unpaid taxes. So you'll have to pay off what is outstanding on the other ones and in full. And if there is a conditional order from the provincial mediation board, the municipality may be impacting the right of the previous owner to those surplus proceeds. So be cautious here. When tax title property is sold, the proceeds must be distributed in the following order. First off, prior to any other distribution, proceeds will be applied to Dominion liens, those filed by federal governments or agencies. The only one that I can think of, and there may be more, but Canada Revenue Agency. And like I said previously, if CRA has an interest, you may want to contact them before actually taking title to see if they'll negotiate on what is owing. After that, all costs and expenses legally incurred during this process of obtaining the title. This would include advertising, tax liens, and registered letters. If the property is sold for the exact value or less, the balance remaining after the costs are taken off must be prorated in accordance with the amounts outstanding between all of the taxing authorities involved. So if you received or accepted an offer that is less than the taxes owing, and after the federal liens have been paid, after the tax enforcement costs have been taken off, then you would apportion it between the taxing authorities, which most likely would be municipal and education. If the tax title property is sold at a profit, all taxing authorities and provincial interests, if there are any, must be paid in full. And after all of those, if there are still surplus funds, in all likelihood, they'll go to the previous owner. This is fairly standard condition from the provincial mediation board. If there was no conditional order, then the surplus proceeds would belong to the municipality. Again, that doesn't happen very often. All right, so now I'm going to move towards the non-title collection, which is in the Municipalities Act. So even though the initial part of tax enforcement is a shall, council may choose to proceed with the non-title collection. Non-title acquisition options exist in the Municipalities Act, like I said, and they are covered through section 318 to 338. And these options include actions such as suing the taxpayer, which is a great option as long as the taxpayer has the means to pay it. If you sue someone who has no money, you can't get money from a rock. You can intercept rent. If the property is occupied by a tenant, the municipality can send a notice to the tenant requiring the tenant to pay the rent to the municipality until the taxes, including costs, have been paid in full. Similarly, if improvements are damaged or destroyed and taxes for those improvements are unpaid, any money payable pursuant to any insurance policy for loss or damage to those improvements is payable on demand to the extent of the unpaid taxes by the insurer to the municipality. You could even do this step while you're doing tax enforcement. If the property is being rented, you could direct the renter to be paying their rent instead of to the owner, to the municipality to offset those taxes. Next option would be seizure of goods. If a distress warrant has been issued, a civil enforcement agency or a designated officer shall place the sufficient goods under seizure to satisfy the amount of the claim shown in the warrant. For this part only, goods include house trailers. Preventing the demolition or removal of improvements. No owner shall demolish or remove any improvement with respect to which there are taxes outstanding or that is situated on land with respect to which there are taxes outstanding, without the prior consent of the municipality. If the owner is convicted of contravening this, the convicting judge may assess and order damages against the owner in an amount not exceeding the outstanding taxes. If an improvement is removed contrary to this, within 12 months after the date of removal, the municipality may, by its authorized bailiff, seize the improvements in its new situation or distrain on the improvements for the unpaid taxes and costs and sell the improvement in the same manner that goods are distrained for taxes may be sold. Some of the benefits of pursuing these options are allowing the municipality to move faster to collect. There's no requirement to wait until a tax lien has been registered on the property. In some of these cases, if taxes are due, remember taxes are due when tax notices have been sent and the assessment roll has been confirmed, the municipality can act. Potentially have the ability, and another benefit is potentially having the ability of collecting current taxes owing at the same time as tax arrears. When you're doing tax enforcement, through the Tax Enforcement Act, you're collecting on arrears, not on what's owing, not on the current. It's just on the arrears. These methods provide you the ability to collect on the current as well. And another benefit is keeping the property taxable. For some municipalities who have a declining tax roll or tax base, this may be ideal for you. Kim Anderson, he's a lawyer with the firm Robertson Stromberg. He's written a really good paper on these topics, and I've provided a link near the end of this presentation where you can find it. All right. The options are the same to try and collect outstanding taxes from oil and gas wells. Council does have the ability to pursue tax enforcement on wells. However, the land the wells are on would be subject to tax enforcement. So the municipality would be forcing the hand of the landowner versus the well owner. Another option, if the oil and gas wells are producing, is to give the purchasers of the oil and gas notice that the owner or operator of the well has failed to pay the taxes levied, and you direct the purchaser to remit the money to the municipality. The municipality would then use that money to offset the taxes owing. To find contact information to obtain oil purchaser information can be found through the Ministry of Energy and Resource, and contact information to obtain gas purchaser information can be found through Sask Energy. Alternatively, if the wells are not producing, the options are the same but may not be ideal. The municipality can sue, they can seize goods and distrain removed improvements. And again, if these options are of interest to you, we strongly advise you to speak to your lawyer on the proper steps. And collection from Crown leased land. Unfortunately, in these situations where the lessees are not paying the taxes, tax enforcement is not an option. Cannot do tax enforcement on Crown-owned land. However, the municipality does have the ability to sue the lessee, or alternatively, to contact the appropriate ministry and make them aware. I've been told that the Ministry of Ag will pay back taxes up to 2 years. If they're notified within 2 years of tax arrears, the Ministry of Ag will pay those 2 years. So it's very important that the admin notify the appropriate ministry sooner than later. And that's really going to bring us near the end of our my presentation here. Some of the resources that we have available, you'll find on the Saskatchewan.ca website. There is a tax enforcement manual. It's a bit outdated. I think it's from 2015, but I still have it right next to me all the time when I'm discussing tax enforcement. We do refer citizens or public people to the Citizens Guide for Municipal Enforcement. so that it helps them understand. There are tax enforcement forums on the Saskatchewan.ca website, and there's also a 3-part tax enforcement webinar. And then I have hyperlinked here the website to find that Kim Anderson from Robert Stromberg, his paper on non-title acquisition collection. So now we will open it up to any questions. And Adam, I believe I'm going to hand it back to you right now. If he is there. And maybe while we're waiting on him, one thing I did not provide here, you'll see the inquiry line is 306-787-2680. That's to speak to any advisor. If you rather email your questions, feel free to email them to muninfo@gov.sk.ca. That's muninfo@gov.sk.ca, and they'll get filtered to one of us advisors. And sorry, Brian, I believe not Adam, you.
That's okay. Thanks for that presentation, Tobi. We do have a few questions in the Q&A box already, but I'll just throw out a reminder, if anybody does have a question, they can put it in the Q&A box and we will get to them in order here. I see I've got a couple. Adam's been poaching from the chat and moving over to the Q&A, so either one will work and we can probably find it and get it. If we somehow miss your question or you think of it afterwards, you can just forward it along and we can make sure that we get an answer for you. As well, I saw there was one or two that were having some technical difficulties, and we will work with you to ensure you get the presentation, as well as any questions answered. And I believe this is being recorded, so there will be a video of this available on the website as well. So with that being said, I will go in order of how the questions were put in, Tobi. And the first one is, we took over a property that has a semi-truck. Can you speak to disposal of vehicles?
I know you can do it. I don't know how. Contact SGI. Essentially, you will be the owner of it, but how you would sell that, the bill of sale, I'm not quite sure. So give SGI a call. They should be able to assist you on that.
Okay, thanks for that. We got a few more coming in here. Adam, if you want to just keep track of those, and I'll keep going through the ones we have just so we don't miss any. So the next one we have, Tobi, is, what if there was a mortgage registered against the title? Does that get paid out from the proceeds of sale?
Okay, that's why if there's a mortgage registered on the title, you would send all the notices, the 6-month notice, to all registered interest holders. That would go to the mortgage company. Their interest would get removed if the municipality takes title. I always breathe a little bit easier when I was doing tax enforcement, and I saw that there was a mortgage on it, because 9 times, if I could speak right now, sorry, 9 times out of 10, the mortgage company is going to pay that. And then they become the owners and they can sell it.
Okay, great. The next one I have is, water for certain parts of the RM is provided by a utility board. They have one property that has arrears and would like to have this added to taxes. Could you review how to do this, please?
Okay, they can be added to the taxes. What you need to refer to is Section 369 of the Municipalities Act. It speaks to that. Give us a call on that one. There's a few more steps that may be needed to be taken, but yes, if there's a public utility board, they do have the ability to add it to the taxes for the persons that aren't paying. But 369 speaks to the process.
Okay, the next one I have says, do you serve the notice of intent before council passes a resolution to continue in phase 2, or can you serve the notice of intent before starting phase 2?
Either way, as long as it's served at least 15 days prior to you sending Form C. So if you're pretty sure council is going to proceed, you could always send it ahead of time. Or you may want to wait for that resolution of council and then send it. But just make sure you wait those 15 days. Did I provide a link or the website for farm debt mediation? Just checking my notes here. And I did. You can even Google it because you have to serve notice on farm debt mediation services as well as the registered owners. The website actually has a pre-populated form that would give notice to the farm debt mediation services.
Okay. Yeah, if we don't have that in the presentation, we can find that and make it available as well. But yeah, it's probably easy for most people just to Google it and it'll be right there.
Yeah, and I do have it. I just checked my notes here and it is on there. So
okay.
Have a look there.
Okay. Yeah, just a reminder, if anyone does have questions, you can throw it in the Q&A box or the chat box, and we're kind of going to go through them here. I have another one. It's not as so much a question, but just a comment, as someone has stated that Ag is no longer paying 2 years. They only do 1 year, according to a document that was sent just in December. So,
okay, good to know.
And then the next one I have is a comment regarding disposal of vehicles. There is information in the Garage Keepers Act for selling the semi.
Garage Keepers Act. I've never heard of that.
Neither have I.
I wrote that down. I'll have a look. Thank you.
Okay, I'll just take a quick look. I'm not sure if we have. I'm not sure if we have any more at this time. I do have another comment. Oh, here we do have one more. What about other financial institutions who have a lien, but who cannot reach them or make contact?
The financial institutions can't make contact, or who can't make contact? Sorry. Is it?
We'll just see
Or
if
is it
the RM can't make contact. Is there
with the financial institution?
Mail was returned. Yeah, the RM can't make contact during TE.
Okay. So one thing you want to pay attention to with the registered letters is the reasons. If you're receiving the registered letter back, there's typically a little box on those registered letters with a check mark required on one of them. Some of the responses, this is just summarizing, maybe after are moved, not picked up. If it's not picked up, it's still deemed served. Registered letters are deemed served from the date that the postmaster stamps or mistress stamps the registered letter. So if they are just not, they're just refusing to pick up their mail or that registered letter is still deemed served. What you may want to try is just sending it by regular postage as well. The reason I suggest that is if it's actually going to be contested in the courts, you've shown the judge that you've went over and above what is required in legislation here. Now, if the address is unknown, you've made all reasonable efforts to try to find the address of the owners and to no luck, you can advertise the notice in the newspaper for 2 consecutive weeks, and then that is deemed served. And it speaks to that in the Tax Enforcement Act and actually in our guide as well.
Okay, great. Just looking through the chat, Barb's asking, yes, Barb, we can get you the PowerPoint presentation available after this. You can just reach out to Adam and he can provide that. I have another one here. If a property is forfeited for taxes owing, does the tax enforcement process need to be followed in its entirety?
No, someone could actually give back their property in lieu of taxes. If that is the case, you still treat it like it's tax title property, but you don't have to carry out all the notices and waiting the 2 years. Tax enforcement, if you keep really tight timelines, it's about a 2-year process. So if someone just gives back their property in lieu of taxation, you can take it, but then you treat it as if it was tax title property. So within 1 year of acquiring it, you would put it up for sale by auction or tender. Now, the one problem that might come with that is the interest. If there are other interests on title, will not get waived. So you might want to talk to your lawyer about that first.
Okay, Toby, I've got another one. If a council member is behind in taxes, can they be removed from council?
No, we actually get that question quite a bit, and there's no authority to remove a council member for having arrears in taxes, nor an administrator. If the administrator resides in the municipality in which they work, there's no authority to fire them or suspend them until they're current on their taxes.
Okay, yeah, that's good clarity, because I know we get that at in our conventions time to time too, as resolutions and stuff like that. So that is a question floating out there. Next one I have is, what happens if the property owner is deceased or has moved away?
Okay, I think I touched upon if they moved away already, if the address is unknown. You would advertise in the newspaper for 2 consecutive weeks, once for 2 consecutive weeks. If the owner is deceased, we hear from a lot of administrators that they are reaching out to their relatives to try to find out how to dispose of this property. The relatives at this point really don't have a say. If the deceased person has an executor of the estate, that person would make the decisions, and that's who you would serve it on. Or if that's not the case, or it's not registered on the title, what you would do is you would try to obtain a surrogate certificate, and you would send notice to the, sorry, I'd have to look at the notes for this one. You would have to basically apply to the wills and estates. It's going to be through the Court of King's Bench to see if there are any other interests, surrogates on it that you could be serving notice on. If there isn't, then you would serve notice on the Office of the Public Guardian and Trustee. And again, this information is in our tax enforcement manual, but if you want to discuss more, feel free to give us a call and we could discuss it a bit more with you.
I'm impressed that you called it Court of King's Bench, because I still keep calling it Queen's Bench. Tripped up, so.
I almost did. I caught myself.
Yeah, exactly. Okay, just looking at the list, we do have a couple more that came in. The next one is fairly short. When should a tax lien be removed?
Tax liens should be removed when the tax arrears have been paid in full. If they're making partial payments, that's awesome. Encourage them to keep proceeding, but that lien does not get removed until the arrears have been paid in full. So if they're almost done, or almost paid in full, and then it goes into the new year and they're current, have now been put into arrears, it's until those arrears then have to be paid in full as well.
Okay, just one final reminder, if anyone does have any more questions, you can add them to the chat or the Q&A boxes now, as we are getting towards the end of our list of current questions, but that's fine. I do have one more that has come in, and it reads, does council know the names of people in tax arrears?
No, that's not information that should be provided to council. I used to always ask my council when they would ask, well, whose property is that? Whose property is this? It really does not involve them at this point. I always ask council, why? What are you going to do? Door knock? That's just going to get them into trouble. They really do not have the ability to do that and should not be doing that. Let the process work. So the short and sweet to that is no, council does not need to know the names of people in tax arrears.
So what is the information that they should know? Is it just locations, addresses, that type of stuff, or?
Yeah, it's going to be like the title information, the legal land description, the amounts owing. And then when you advertise it, it'll also include the costs of the advertisement broken down, proportionate to how many people are in the tax enforcement list. And I think the roll number as well.
Okay. All right, just looking at the end. Oh, we may have one more coming in. So I do have, and then a follow-up, I'm guessing on what about if when you get the property back, can council know then?
Know then who are the previous owners?
Yeah, I'm not sure. Barb, do you mind just expanding on that a bit? I'm not quite sure where you're getting at. Yes, she says yes.
Again, I don't know why that would affect them other than if there's proceeds, they'll get paid to them. But it really does not affect council or have anything to do with what they would be doing to know who they are. Council has the ability, like anyone else, when that list is advertised, to look up on ISC or whatever means they have to see who those property owners are. But that should not affect their decisions on how to move forward or if to move forward.
Yeah, we just had another comment on the chat as well. Yeah, council can look up the property on an RM map just as well as anything else can.
But I would strongly encourage council not to go door knocking or anything like that. That's going to get you into trouble.
Yeah, for sure. Okay, well, I think we're caught up, so I'll do one last call. If anybody has anything else they would like to add to the chat or the Q&A, you can do so now. In the meantime, I can say thank you, Tobi, for this. This was great information, and I think we had quite a high attendance, so it was definitely a hot topic for our membership. And we're thankful for you and the ministry for putting this together and doing this for us today. And if I see nothing else in the next 10 seconds, I guess we can wrap it up and call it a webinar. Oh, we do have one more. See, if I force them, we keep going. Is using the non-title acquisition options considered discriminatory?
I don't know why they would be. Yeah, sorry. I can't think how that would be discriminatory. Like human rights, you mean? Or again, I do strongly encourage, if you're going to use the non-title collection, to really work with your lawyer on it.
The example they have is if you use it before a lien is registered, i.e. not wait for the end of the process.
No, you could run the two processes at the same time, or you could even start. That's the one benefit of the non-title. As I was saying before, taxes are actually due when the roll has been confirmed and tax notices have been levied and the notices have been sent. So you could, I don't know if that's something you'd want to do, but you do have the ability to collect on those as soon as they are due.
Okay, we just hit the 5-minute warning left for the meeting. So if there's anything else. All right, there's a few more questions on that information, Tobi, but they just said they can take it offline and they'll may reach out to you and just discuss further.
Yeah, absolutely.
All right, if anybody has anything else. I see people thanking us. I guess I can continue with my segue to exiting out and we can take this online. And if something does come up with anybody afterwards in an afterthought, or maybe in an hour or two, once you've thought about it, feel free to reach out and we can make sure we can get that information for you as well. This has been recorded, so it will be available on the website to review or further. And we do have the presentation available to send out if anybody wants it as well. So Adam, seeing nothing else, I think we can wrap it up and call it a done deal.
Awesome. Well, thank you, everyone.
Yes, thank you very much. And thanks everyone for attending. Have a good day.
Bye.
Bye-bye.